So I'm happy to make a start.
Okay, so
Let,
I'll just
yeah,
I'll just okay. Good afternoon, everyone. Thank you for joining us again for the second edition of the MBA ICLE Civil Litigation Training. We have two sessions today, as usual. The first session is we have very distinguished facilitators anchoring today's session. The first session is going to be anchored by Mr. Eric Obansugbe, KCSAN. It's on the very, very important topic of pleadings, which is at the core of civil litigation. So we are privileged to have him to anchor this session. I will just allow my colleague, Mrs. Mabel Okereke, to do a brief introduction, and then we'll dive straight into the presentation. Thank you very much.
Thank you, Leonard. So indeed, it's an honor for me to take Casey's profile, quite inspiring. He was born in Lagos in 1962, a graduate of the Hull University in the UK. He was called to the Nigerian bar in 1985, as well as the Nigerian bar in 1986. As a lawyer, he has broad international practice with particular interest in Africa. He took silk in the UK in 2002 at the age of 39, and was the first Nigerian practicing abroad to be promoted to King's Counsel. At age 35, he was appointed a part-time judge of the Crown Court of England and Wales, the youngest in the country at the time. He spent 7 years as a member of the Judicial Studies Board, England and Wales, was responsible for training of judges and recorders. He has served on several committees of the General Council of the Bar, including professional discipline, education, and race relations. Leonard Silk Obansugbe was promoted to the rank of Senior Advocate of Nigeria in 2005 and elected as a bencher of the Gray's Inn in the same year. In 2006, he was elected a Fellow of the Royal Society of Arts. In 2010 and 2024, respectively, he featured in Powerful Media's Power List as one of Britain's 100 most influential Black people. For almost 20 years, he has headed the Pump Court Chambers in London, a large commercial law set of chambers in the Temple. He's a visiting professor of law at the City University and a senior fellow of the Nigerian Leadership Initiative. In 2004, Leonard Silk was appointed a member of the National Competitiveness Council of Nigeria. He's a founding member of the British Nigerian Law Forum, now 20 years old, and also a founding member of the Central Association of Nigerians in the UK. Leonard Silk is a passionate lover of arts. He's also a trustee of the Yinka Shonibare Foundation and New Curators. He is a past member of the Tate African Arts Acquisition Committee. 2020, he featured in Nigerian Guardian's publication, 60 Nigerians in 60 years, Making Nigerians' Lives Matter, celebrating 60 years of Nigeria's independence. In 2021, Leonard Silk was named Nigeria's magazine's 20 Persons of the Decade. It's an honor to have Leonard Silk with us today. And without much ado, thank you so much, Leonard Silk, for acceding to our request to be on this training.
thank you very much for that generous introduction. And good afternoon, distinguished colleagues. I think it's appropriate that I begin with my gratitude. I've been greatly assisted by the NBA team. I begin with my learned Silk brother, Tola Oshobi, SAN. Thank you very much, SAN, for setting the scene for me and giving me every assistance. Mabel Okereke, Mabel, thank you. And of course, Sarah, who is assisting us. I also should remember my pupil who is working with me at the moment in London, Emonye Adeku, who has helped me as well. So it's a real pleasure to be here. This is a very important initiative that the MBA does every year as part of its training, and I applaud it. So I have been set the task of dealing with pleadings, which you may think on the face of it is a very dry subject, but it's not. It's key to our success as lawyers. Any good set of pleadings starts with an author having a very clear sense of what he or she is setting out to achieve. What you are seeking to achieve is to inform both the court and the other side in clear and concise terms of what your case is all about, what you seek and why. Therefore, as plaintiff claimant, precision in the formulation of the claim is key. The same, of course, is equally true of any defense or counterclaim. Bear with me one moment. My apologies. I'm in Accra, in my hotel room, and there's some work going on, so I just went to go and try to speak to them. So going back to what I was saying, in addition to precision, there are other more subtle techniques that can be employed which will bolster a good pleading, and I want to talk to you about that today. So, the first is the manner in which the case is drafted. So, if rules are followed, there is not necessarily a right way to draft a case. There is certainly a wrong way to do so. In terms of the right way, nothing beats a tight, logical, well-expressed case, as it will always have a good psychological effect on the judge. Secondly, playing to your strengths. It's quite possible not merely to give a clear and concise statement of defense of your case, but to do so in such a way that maximizes its strengths. For example, in a defense, you can play on the weak points in your opponent's case in a manner which enhances the strength of your own. In all too many cases that I've seen, defenses correctly deny liability, and technically they meet all the rules as to traversing the claim, but they fail to set out matters concerning the defense which are not merely proper to be included, but also, if they had done so, will enhance the case immeasurably. By way of a hypothetical example, and I think it's important to get to the practical side of our work, I'm dealing with a case in which the plaintiff claims 200 million naira. He alleges that the defendant ordered 5 tons of iron rods from him to be used in the construction of a bridge in Onitsha, to be paid for 7 days after delivery. He says they were delivered and that the defendant thereafter refused to pay. The defendant, for whom you act, says that he rejected the consignment because they were split and rusted, and that he did this on the strength of a report from an engineer registered with the Independent Association of Mechanical Engineers, which they said were defective. The relevant sections of the statement of claim, and this is a hypothetical case that I essentially have drafted for by way of illustration. At all material times, the plaintiff carried on business as a manufacturer and supplier of iron rods and other artifacts. By an all agreement made on 8th January 2020, the defendant ordered and the plaintiff agreed to supply 5 tons of iron rods in consideration for the sum of naira 200 million, to be paid within 7 days of the delivery thereof. The plaintiff duly supplied and delivered the said iron rods on or about 20th January 2020, but in breach of the said agreement, the defendant has refused to pay the agreed price or any part thereof. The relevant sections of the defense read as follows. Paragraphs 1 and 2 of the statement of claim are admitted. It was an express, alternatively implied term of the said agreement that the said iron rods should be of satisfactory quality and or in entire condition without splits, cracks, or blemishes such as might weaken them, save that it is admitted that the plaintiff purported to deliver the said iron rods on or about 20 January 2020, and that the defendant thereafter refused to pay for them. Paragraph 3 is denied. In breach of the said agreement, the said iron rods were defective and or of unsatisfactory quality, in that the vast bulk of them were cracked and ridden with rust. As a result, the defendant, as he was entitled to do, rejected the said consignment. In the circumstances, it is denied that the plaintiff is entitled to the due sum claimed or any part thereof, the reasons alleged or at all. Now, this is a perfectly adequate pleading on both sides, but my question is, how do you enhance the defense, for example?
Recording in progress.
Just to deal with that, you can do it in this way. In breach of the said agreement, the said iron poles were defective and/or of unsatisfactory quality, in that the vast bulk of the same were cracked and ridden with rust. Here is the addition. The defendant will rely as part of his case on a report from a mechanical engineer from the Independent Association of Mechanical Engineers dated 22nd January 2020 as to the condition of the said poles. This report is annexed to this defense. And of course, where we front load in Nigeria, you can, of course, put your documents out there, or at least you can provide the expert report at some appropriate time. As a result, the defendant, as he was entitled to do, rejected the said consignment. So the difference here is that you've alerted your opponent to the existence of the report, which will emerge at some stage in any event, so there's no secrets. From a tactical point of view, however, you've gained a psychological advantage over your opponent, who may start to appreciate that he has an uphill task. In addition, judges are human, and there is a realistic possibility that consciously or subconsciously, he or she, reading the papers, may begin to look to the plaintiff to justify why faulty goods have been supplied. In addition, you may increase the chances of an early and favorable settlement. Of course, that is in your client's interests, although sometimes as lawyers, we wonder whether it is in our interests, but we must remember that anything in our client's interests is also in our interests. Next point, get over and under every aspect of your case. It is extremely important that you know your case inside out. Now, in order to do that, fundamental that you obtain full instructions before embarking upon a pleading. Notwithstanding the irritation that this often causes a client, who typically will give you scant instructions and expect you to fill in the gaps. Often a client has said to me, having given me instructions, sir, please carry on and prepare the case. Really saying to you, these are my instructions. If you can fill in the gaps or pretty much make up bits that will strengthen my case, you cannot do that. It's unethical. What you need to do is go back to the client, to his or her irritation, and grill them, obviously in an appropriate manner, to make sure that you have full instructions. It's better to get it right the first time rather than to have to seek to amend further down the line. Next point, plead in an elegant and economical way. You don't get paid per page. You don't get paid per paragraph, or you shouldn't. You may ask, what is the point of elegant drafting? After all, so long as I've made myself clear, why should style be of any relevance? The short answer can be summed up in one word: authority. Pleading is clearly a form of advocacy, and so why not plead persuasively? Assuming basic legal competence, the most important additional attribute that will distinguish good drafting is authority. Pleading with authority means moving from the mundane and making your mark by taking a case by the scruff of the neck, dictating the action, and essentially showing the court and your opponent you are completely on top of the case. This will give you a clear advantage throughout its duration. The court will know, your opponent will know, and your client will know. Pleading with authority means calling upon a good command of English, cut out the gobbledygook, eradicate pomposity, take out legalese, be clear, simple, and modern in your pleading, using clarity, precision, and comprehension as your essential tools. Once you do that, your pleading will have every semblance of being an authoritative document. Many times in practice, I have received pleadings from my opponent, and when pleadings are extremely well done, you go through a moment, certainly for the first 10, 15 minutes, where you start to wonder how you're going to answer these pleadings, because you know that the person on the other side knows exactly what he or she is doing. And quite often you'll find that you are pretty much boxed in from the beginning from a good pleading. From a bad pleading, you can see gaps all over the place. You can see that it hasn't comprehensively covered the points that ought to be covered, and you can clearly see a way out. So there's a very real difference between a well-drafted case and that is not so well-drafted. The advantages of a well-executed pleading are indisputable. Essentially, you're putting in place the scaffold for constructing a sound edifice, which all aspects of your winning case will be housed. In fact, it might go further and achieve an impact which brings the case to an early but satisfactory conclusion. You have little prospect of doing this if you've not fully thought out from the beginning to the end what it is you're trying to do. Have you fully understood and researched all realistic causes of action open to you, together with their merits and demerits? Have you examined all the remedies available to you, circumstances in which one may arise in your case? And when I say all the remedies, I stress all realistic remedies. A strong pleading is not one which lists every remedy under the sun. Have you decided a preferential order for them? There's no substitute for a full understanding of the case itself and the relevant law. In the absence of either or both of the above, the drafting will be second-rate. Have you fully thought through the best logical way to draft the various causes of action that you wish to set out, so that the alternatives will flow one from the other without unnecessary repetition or confusion? Have you planned out the best way of making your case look formidable, having regard to the nature of the defense or reply that may be raised? Have you thought tactically as well as legally? Many of the principles outlined above equally apply to a well-drafted defense. So turning now to the set-off and the counterclaim, I've mentioned the defense pretty much at the same time as the claim, and so I won't go back to saying much more about the defense, but talking about the set-off and counterclaim. So check to see whether you have a cross dispute for which a counterclaim should be mounted or have suffered any monetary loss which you should seek to set off from the claim itself. The latter occurs where the main defense may not be based on the merits of the claim, but on the fact that the defendant considers that he has a right to withhold the sum claimed on account of other monies owed by the plaintiff. Such a defense is by way of a total or partial set-off. It is part of the defense itself. Therefore, a defense can comprise the following combinations: a substantive defense to the claim, a substantive defense of the claim accompanied by a partial or total set-off, a defense comprising solely of a partial or total set-off. Therefore, separate the sections into defense and then separate the section into counterclaim. So by way of an illustration, further or alternatively, if which is denied, the defendant is liable to the claimant, or as alleged or at all, the defendant seeks to set off against such liability the amount set out in the counterclaim so as to reduce it or extinguish it altogether. So that's one way of doing it. I've set out an alternative which I would suggest is more economical. You tend to get to that point where you feel confident that you've blocked all the routes. Further, alternatively, the defendant will seek to set off against the claimant's claim the sum set out in the counterclaim below so as to reduce or extinguish it altogether. So the difference here is essentially you've kind of cut out what I describe as a without prejudice type pleading, where you essentially deny or cover off everything. More likely than not, it's implied that you've denied things within your defense or your counterclaim. But if you want to obviously make sure there's no doubt about it, you can go the first route. If you've done it in a different way, you can take the second route, which is shorter. So where the sole defense is one of set-off, your entire defense may be along these lines. Paragraph 1 to 5 of the particulars of claim are admitted, subject to the set-off and counterclaim set out below. And then the defendant claims to set off the matters set out in the counterclaim below in extinction of the claimant's claim. Or paragraphs 1 to 5 of the particulars of claim are admitted, say the defendant claims to set off matters set out in the counterclaim below in extinction of the same. So where there is no substantial defense, say for a partial set-off, obviously it'll be slightly different. In these circumstances, it's very advisable that the client makes the payment he considers owed and seeks a partial set-off of that payment or of the amount owed. And I've given an example here. It is admitted the defendant owed to the plaintiff the sum of naira 50 million, which sum was paid to him by way of defendant's check number, and then you obviously set that out in GTB. As the balance of the naira, the defendant claims to be set off the same, and then you add that. So now I end with some advice about the reply. And I think I would begin by saying that a reply isn't something which is automatic. It's important that we remember that, but it is appropriate where the defense may have raised issues which require an answer, and these can be of three types. Where the defense has raised a point for the first time, which requires some clarification or answer from the plaintiff, or where some new matter may have arisen as a direct and relevant result of something which has been pleaded in the defense, or where there may be certain issues to which admissions can be made in order to delimit the extent of the contention at the trial. Otherwise, reply should not be used merely to reiterate your case or matters which have gone before. The reply should not be used in order to raise new issues which should have been set out in the claim in the first place. The proper way forward here is to seek to amend the claim. The reply is different to other pleadings in the sense that it is not an entire document. In other words, although it refers to specific paragraphs in the defense, it isn't not required to be, nor should it be, a comprehensive statement or reinstatement of your case. From a tactical point of view, where appropriate, the reply can be an effective way of cementing your case by underlining the weakness in the other side's case. However, if you're not careful, it can equally appear as a show of weakness by seeming over defensive. Finally, the lesson: plead judiciously, not extensively. Pleading may appear to be a mechanical and somewhat dry exercise. However, if approached properly, it is everything but. It is an intellectual stimulating adventure with which practice and application becomes a powerful tool in your adversarial armor. Thank you very much.
Thank you very much, Leonard Silk. Are we going to this next slide? I understand I have a second presentation. Are we going to that immediately? Is that your preference?
Forgive me, yes.
No, Leonard Silk, can you hear?
Yes.
Can you hear me? Are we going to the next slide immediately?
Yes,
we'll take the questions together.
Let's do that, my little brother. I'm sorry about the pause. As I'm sitting here in Accra, for some reason my room seems to become like a traffic place. So sorry.
No problem.
Each time I have to get up to answer the door. All right, please let's go to the next slide.
Do you want Mabel to post it? Okay, she's doing that already.
Yeah. So Mabel, can we go
to the first
screen?
page?
I'm wondering, yes, please. Yeah. Thank you very much. So this is my second presentation. I'll go through it quite briefly. I thought it was important to begin with essentially the philosophy of pleadings, which was my previous presentation, and to think about why they matter, and ways in which we can improve the way we plead, and to give specific examples as to how to do that. It's a matter of technique and practice. I commend it to you because it's something that will definitely improve you as a lawyer. And so I remember starting out pleading in a loose way and putting too many things in a pleading. But as you gain experience, you become more confident about what to leave out. And I think the critical thing is, what do you leave out? What are you confident about leaving out? And at the same time, not in any way weakening your case. And that is something that you kind of become more confident with time. So that was my first paper. This is probably more technical in a way, and I have gone to authorities from our own jurisdiction in Nigeria, and I like what was said by the Supreme Court judge in this case, Olatuwara. Now, Olatuwara, it must be appreciated that there cannot be a better notice of the case a party intends to make than his pleading. It is a mere notice and can never be substituted for the evidence required in proof of the facts pleaded, subject, however, to an admission made by the other party. Unless a party through skillful cross-examination discredits the case of the other party, he is still bound to leave evidence in support of his own pleading. So I pay tribute to the JSC, kind of expressing what a pleading is, a notice of the case to the other party. It is not evidence, and it should never be evidence. So it sets out the facts and disputes of the issues to be settled. To do this, a pleading must be legally relevant. So separate out the law. You're not essentially pleading law, you're pleading facts. Of course, you have to plead your actions, your causes of action, but be careful to plead facts that essentially support the cause of action that you then claim. Make sure it's specifically specific to allow a party who looks at your pleading and indeed allows you to put together all the required evidence and advance your legal arguments. A clear statement of each claim being made, all the defense or denials, each of those claims, and the formal basis for the judgment to be entered. As I said before, a pleading is not evidence or the legal argument supporting a party's case. It is an aid in the enforcement of legal rights, but does not define legal rights. It's a means to an end and not the end itself. This is pretty standard, describing the categories into which pleadings fall. I've dealt with a reply, obviously counterclaim, but I included that just for your information. So this section deals with what are pleadings. We all know, I think, what pleadings are, but it can include persons who were not made parties to the claim by the claimant. And that obviously we have the relevant rules or orders that deal with that. It can include separate third-party proceedings against a third party for contribution, indemnity, or any other relief. These can be commenced. And then obviously with non-party pleadings, the third-party pleadings and process, they facilitate a quick and efficient disposal of all connected issues. So they're actually quite a useful tool where you bring in a party that's not initially claimed against by the claimant. There is a misconception that the affidavit filed along with the writ in the undefended list procedure constitute a pleading. It does not. The undefended list procedure is specifically designed to ensure quick disposal of liquidated claims where there's no defense. The affidavit filed along with the writ is evidence intended to show that the grounds for engaging in the special procedure are met. Similarly, the affidavit disclosing a defense on the merits filed by the defendant and the affidavit filed in response are not pleadings. In both cases, they are evidence of the defendant's case. This is why the court has the discretion to order pleadings under Order 35 FCT rules. And of course, as you know, affidavits must comply with the Evidence Act. I carry on with what is contained in pleadings. And the essential point that I made earlier is that you need to look at pleadings as being a tool for winning over the judge. Your pleadings should clearly state the relief you're seeking and the factual basis upon which that relief is sought. From a defendant's point of view, of course, you must state what is admitted and what is not. It should clearly state what is denied and the facts supporting that denial. The general denial alone risks being struck out for being evasive or a non-denial. There is the case of ATE Company Limited, where the Supreme Court addressed finer points of pleadings, which claimants and defenders must consider when drafting pleadings, particularly where you're claiming special damages. These must be specifically pleaded and quantified in a way that provides detail. So figures must be given, fully pleaded, and setting out what the nature of that damage is. Because as you know, special damages must be specifically proved. Numbered paragraphs clearly are the best way to do this. And of course, the pleadings must be dated and signed and of course paid for, otherwise you're going nowhere. Pleadings should not be embarrassing, scandalous, extraneous, or vexatious, not be presumptions of law unless expressly denied or expressly in issue, must not be evidence, must not be legal submissions. That happens far too often, and conclusions, inconsistent facts and unnecessary repetition. You risk being vexatious, and anything obviously constituting an abuse of process. So here I've just given some timelines. Of course, that can be easily researched, so we don't need to spend much time on this, depending, of course, on where you brought the action. And of course, that requires some thought. Where are you bringing the action? Are you bringing it in the Federal High Court? Are you bringing it in the State High Court? Why? Which court has proper jurisdiction? All of those things obviously need to be thought about before you launch your action. And then we come to amendment. General rule as to amendment is that they can be amended at any stage before judgment. It's only a general rule. Obviously, whether you can amend or not will be a matter of the court's discretion. And if you wish to amend, the earlier you amend, the better. You can also amend after evidence. Of course, you shouldn't amend to essentially introduce a new course of action. That usually causes prejudice, although it has been allowed on occasions where it can be shown that no prejudice is suffered. But it's very difficult to imagine a case where no prejudice is suffered, where you're amending to essentially introduce a new course of action. So if we can go to the end, please.
That's the end, Leonard.
Yes, okay. All right, thank you very much, Mabel. So, distinguished colleagues, that brings to an end my presentation on pleadings. As you've seen, I've prepared 2 PowerPoints and an underlying paper. I hope it's been helpful. And of course, I'm available to discuss matters, pleadings, any issues that arise. Thank you very much.
Thank you very much, Leonard Silk. I know I know you are in transit. You're actually not at the place. You're in Ghana, but you made the sacrifice to make this presentation today, and we're very thankful. It's been very good, very brilliant, very appreciative. We have a very, and I'm sure we have a large audience, and we're thankful for the effort, demonstrable, manifest effort that went into preparing this slides, which I'm sure a lot of our colleagues will find very useful. We'll share it with them in due course. Thank you very much. I'll hand over to Mabel to take to answer the question and answer. Our colleagues are enjoined to send their questions to the Q&A box. So if you have any questions, please post them in the Q&A box so that we can pick them up, and then the Leonard Silk will answer the questions. Thank you very much. So the Q&A box is open. Please post your questions there if you have any questions. Thank you very much.
Thank you.
Thank you, Leonard. So the first question is from Joshua Tony, and he says, can a statement of defense be amended to include a counterclaim before CMC or trial?
Yes, you ought to be able to amend your statement of defense. Now, it may be that you need permission to do that, the court's permission, but there's no reason why you can't apply for permission to do that. Sometimes I've had cases where I've sought to cooperate with people on the other side by seeking their, essentially saying I'm intending to amend the statement of defense. Is there any objection? And quite often, in fact, because everyone's trying to get to the issues, I haven't had objections. So it makes it easier to get court's permission if you need it.
There's another one here. Is it better to file separate motion for notice to produce documents or to include it in your pleadings? And if so, how do you effect or bring the paragraph to the notice of the court?
I didn't hear the second part of the question. The first part of the question, in my view, it is better to file separate notice to produce documents, because otherwise you tend to start to confuse your pleadings with the evidence, and that's something you definitely don't want to do. The pleadings, for them to have maximum effect, should essentially stand as your case submitted to the court. The evidence is a separate thing, and I think if you're seeking to obtain further documentation, then you should do that on notice by way of a separate application, not as part of your pleadings.
The next question says, is it possible to make the slides will be available, yes. Can a party amend his pleadings where he has been served with the final written address of the other party?
That sounds ambitious. You can try. I don't think you'll succeed, because each side will essentially have laid out their cases. They will have pleaded their cases. They will have called evidence in the case. The judge would have heard the evidence and would have made submissions, and then you essentially are looking to amend your pleadings. I think you find you have a very uphill struggle, because the argument that you'll meet is prejudice. And what a judge is entitled to say is, if I were to allow this application, essentially we'd have to start the case again. And I don't think you'll succeed in starting the case again. It'll have to be something pretty seismic to persuade a judge that you can amend your pleadings after written addresses.
Thank you. Leonard Obina has asked if you could kindly recommend any book on pleadings.
You know, the funny thing is, pleadings are so important, right? But there are very few books on it. But I can recommend what I have benefited from is certainly in the UK, the civil litigation books that you study, or if you're converting to law, they have quite good sections on pleadings, which I think, put it this way, Mabel, I can certainly send some detail on where people can look for pleadings. There's another book, which I don't know whether the learned self has come across. It's called Pleadings Without Tears, which is an apt title. Pleading Without Tears. And that is prepared by a practitioner here not in Ghana, in the UK, who actually managed to write a book on pleadings in a way that's attractive and quite funny. And he really is basically essentially what he was saying throughout the book, and he takes a lot of examples. Essentially what he's saying throughout the book is that we can make pleadings far more complicated than they actually need to be. And sometimes it's a question of us taking a step back, simplifying the case, deciding what really matters, and making sure that we're economical and attractive. Okay, so I interrupted you, Tola. I don't know whether you come across the book.
I would just suggest, I haven't come across that particular book, but I think one book that used to be very popular earlier on when we was there's this book, Bullet and Leak on Pleadings. I think it's a British practice text, which I find very useful. That we also have the Atkins court forms, but one has to be careful when using Atkins court forms. It's actually an encyclopedia of pleadings. It's a British encyclopedia, so it teaches it has both commentaries as well as templates and precedents of pleadings for different courses of actions, and it tells you how to plead them, and then it gives you some templates. Again, but you cannot use templates. You have to be careful in using templates and precedents because you cannot use them slavishly. Obviously, the facts of each and circumstances of each case differs. But the Atkins court forms, I find them, particularly for young lawyers, I always encourage my colleagues to use the Atkins court forms. At least read the commentaries, read the recommendations, and look at some of the precedents and the templates in the Atkins court forms, and then Bullet and Leak on Pleadings. Those are the two books. Of the Atkins court forms is not just a book, actually. It's actually an entire encyclopedia on pleadings. Those are the two that I would recommend. Thank you.
No, agreed, definitely. Bullet and Leak is like it's a very thick book. It's a very comprehensive book. And Atkins court form. The good thing about Atkins court forms is it actually also includes some commentary on the law. So it's not just the pleading, the examples.
Yes, it does.
Yeah, so it's actually a very good one.
Exactly.
It's a very good one. But as you say, it's important to make sure that you don't copy it completely. You have to adapt it to your case, otherwise it doesn't quite fit. The one that I spoke about is, I think it's sort of more down to earth than those weighty books that you referred to. Although of course you have to get to the weighty books, but Pleading Without Tears is quite a funny way of approaching it. It has a very practical approach.
I own a copy. It's by William M. Rose.
That's the one, Pleading Without Tears. Yes, you have it.
Thank you so much, Leonard Silk. Frida says, when amending a statement of claim and oath, is it a must to underline the new or additional paragraphs? Will failure to underline amount to invalidity of the amended pleading?
I think it depends where you're practicing. First of all, it is correct process to underline the amendment. The importance of that is that the judge can see what's new and what you've added and how you've amended the case. Now, if you don't do that, if you essentially amend without underlining, I think a lot will depend on the judge as to whether the judge takes the view it's defective or not. I don't think necessarily it's defective. And I think that's more in line with where we should be less technical, rely less on process and try to get to the justice of a case. But I can imagine, and I wouldn't be surprised if some judges say, well, this pleading is defective. because you haven't underlined sections where you've amended. And I think to play it safe, you really should underline it. The way I was taught throughout by people that essentially really passed on good habits was that you should underline in red the sections that you have amended. Now that's not essential, but I have continued that advice where I underline in red the sections that I have amended, and I cross out the sections that essentially I have disposed of or dispensed with.
Thank you. This is from Disu, where an interested party who was not part of the original suit seeks to appeal against a judgment, and the interested party filed the evidence they seek to rely on with their motion for joinder, or do they need to be joined to the case and then file an application to adduce further evidence? This question is because in an appeal, you can't bring in new evidence without seeking leave of the court. Yes, it's a way of saying pleadings were not filed by that party at the lower court. How does that impact?
Well, my answer, and I'll be interested in what other people on this session think. My answer is that you need to be part of the case before essentially you can participate in it. So you need to first apply to be joined in whatever capacity you think you're entitled to be joined, and then you essentially add such documents as you think are part of your case. Because otherwise, if you're not essentially part of the case, then it's difficult to see what your locus is in a case. You may as well be in a parallel case speaking to the skies. But others may take a different view. I'd be interested in hearing what people think.
Can you run that question again? I think I didn't quite get what the question was about.
So where a party interested was not part
Yes.
of the original suit, that's at the lower court, but seeks to appeal the judgment, and that interested party file evidence, seeing that they have not adduced or filed pleadings at the lower court, and you're not allowed to bring new evidence at the appeal.
That's a tricky one. Luckily, we have Mrs. Funke SAN on the call. I know she's been very silent. Maybe she wants to intervene and share her thoughts on this question. Leonard Silk, can you hear us?
I can hear you. I do not wish to intervene. My thoughts would be that the party interested who is seeking to join would bring an application for leave to adduce new and fresh evidence. And the grounds upon which he would be bringing that application would be that he was not a party at the lower court. And the reasons why he was not a party at the lower court, not that he was standing by, but that he has just become aware of the proceedings, perhaps because he's just been served with a copy of the judgment. And that having reviewed the judgment and the record, there's certain evidence that was not presented to the lower court that is relevant to him as a person interested. That would be the way I would go about it.
Thank you very much. Yeah, but I agree with the I agree with the Leonard Silk, but it's still tricky because you're going to have to But I think that's it. I think that's essentially, but it's going to create some complications for the court. Except the court, of course, is going to set aside the judgment, and that is the court of appeal, and set the case back for retrial with the party interested now, because now being allowed to make file pleadings if it needs to. Otherwise, I think I agree completely with what the Leonard Silk has have said. Thank you.
Thank you.
Thank you, Leonard Silk. We have another question here that says, can a party amend only the claims in his statement of defense after he has closed his? The claims after he's closed his case.
After it's closed his case?
Yes.
You can technically amend your case anytime before judgment, which I hope answers the question. The longer you leave it, the more difficult you will find it to get leave to amend your case. But technically, you can amend your case anytime before court gives judgment.
Thank you. Abubakar says, must a counterclaim be specifically headed? Must a counterclaim be specifically headed, or can it just be included in the statement of defense?
I think as a matter of good practice, the counterclaim should be specifically headed. If you do that, it becomes clear that you're moving on to a claim yourself rather than it being part of the defense. And that is part of the clarity of pleading so that the court is sure as to what it's dealing with at each stage of your pleading. So you do your defense and you must head it defense, again, so that it's obvious that it relates to the claim. The defense ought to cross-refer to the relevant paragraphs in the claim. And then if you have a counterclaim, you then head it counterclaim. And there's a way in which you can essentially marry the two by saying, for example, paragraphs X1 to 7 in the defense are repeated and hereby adopted. Claimant now, or the defendant now seeks to counterclaim or set off in the following manner on the following grounds, and then you set out the counterclaim. But yes, the answer to the question is that you should head it counterclaim. Now, whether you will essentially be struck out if you don't is a moot point, but it'll be frowned upon if you haven't separated out your defense and your counterclaim.
Yakin says, thank you, distinguished Leonard Silk. My question is this: is it legally appropriate and correct to amend the statement of claim to bring the evidence in line with the pleadings? This is after the party has closed his.
Each case will depend on its own circumstances. So if the case has essentially gone through and been heard, and your pleadings don't exactly, or your case has not essentially, you'll probably find that your case won't succeed. You might wish to apply to amend the case to essentially marry up with the evidence, but again, you'll face problems. It's not that you can't do it, but you have to make a very good argument as to why you are doing it and why you should be allowed to do it. The judge hearing that argument always will have to have in the forefront of his or her mind is what is in the interest of justice. Why is it that you're seeking to amend at this stage? Is it that you simply omitted something? Or is it something that was essentially hidden from you? Or is it something that in the case in front of him or her, the justice of the case will be met by allowing you to do what you've asked for? So it all depends, but I would suggest that you face an uphill task unless you can show very good reason why you're seeking to amend to connect with your evidence.
Thank you. Kelechi says, what is the propriety of counsel averring in his pleading as follows? I know as a fact that instead of stating the plaintiff avers that, are there any consequences? When counsel avers, I know as fact, rather than saying plaintiff avers does, are there any consequences?
That's bad. That's bad pleading. That's bad pleading. There have been many times I've sat in court where a counsel has made a submission along these lines. I know as a fact, my lord, that, I know as a fact that is counsel giving evidence. And counsel should never give evidence. The reason for that simple rule is that if the evidence that counsel is giving is false, then clearly you face an ethical problem. Secondly, if you give evidence as counsel you might suddenly find yourself being a witness. And if the evidence is somehow wrong, you're in the way you'll be called or summoned as a witness. You find yourself being cross-examined, and the evidence is untrue or somehow wrong or false. You're in all sorts of difficulties. So I know as a fact, as soon as you start saying I know as a fact, you should stop. Better to say it is submitted on behalf of X or Y. I know as a fact is wrong.
Thank you. During cross-examination, can my opponent ask questions on issues that were not pleaded?
I think technically, yes. So a pleading, right, is, as we've seen, is essentially notice of your case. It isn't evidence, so it isn't the kind of every line or every detail. So a case, once it starts, can be broad, evidentially. But the rule on cross-examination is that when you cross-examine, you should cross-examine to relevant issues. So even though it may not be specifically pleaded, it may be an issue which is relevant to something in dispute. And of course, relevance we can determine in grades. Something can be directly relevant, it can be indirectly relevant, and so on. So the only time that I think cross-examination, well, there may be more than this, but cross-examination starts to stray is where you are essentially cross-examining about irrelevant issues, and that happens quite a bit. So when you cross-examine, you really need to think to yourself, what issue does this question go to? And then you need to phrase the question in a way which is permissible. And when I say permissible, the question should not be a question that essentially asks 2 or 3 questions in one. The question should not be a question that essentially includes giving evidence. The question should be short and sharp and to the point. And you should make sure that it is a question rather than a statement, because there's a real danger when we question that essentially we're making a speech. And the time to make a speech is not in cross-examination.
Thank you, Leonard Silk. I must join Aloysius in echoing a lot of the comments that we have here. Says it's really appreciated. Brilliant presentation. Thank you, Leonard Silk. But I'm not going to ask his question that follows because we are aiming to have a hard stop at 4. The next paper should be on ICT, Internet, and AI in civil litigation. Thank you so much, Leonard Silk. I still have 49 other questions. So you can imagine it's 50 now. We can't possibly take all of the questions. Thank you for availing us with your slides and the paper. I'm sure my colleagues will really, really appreciate this. Over to you, T. Thank you.
Thank you very much. Thank you very much. Let me please, I think, end. I also want to thank Mrs. Ajere Cole, Mrs. Ajere Cole was due to speak today. Because I was in the air, she kindly agreed to exchange the speaking time, possibly at inconvenience to her. So I really thank her. And I want to also end by thanking everybody that's made this possible. I want to thank my colleagues online that have come to support and to give their own experience. And I hope to see you all again very soon when I get back to Nigeria. Leonard Silk, thank you very much for your time.
Thank you very much, Leonard Silk, for your time, for the sacrifice. In spite of the fact that you are traveling, we don't take it for granted. We're very grateful. We thank you very much on behalf of the MBA. Thank you. Have safe flights as you continue your journeys. Thank you so much. You're truly appreciated.
Thank you.
Okay, so the next paper is on the next paper is on ICT, Internet, and artificial intelligence in civil litigation. It's been the presentation is by Mr. Ibrahim Sule, the Director of Nigerian Law School, Kano. This is a topic he's very passionate about, and he's currently undertaking a PhD in this area at Utara University in Malaysia. My colleague will give a fuller rundown on his profile before we go into the paper. Over to you, Ms. Okereke.
Thank you very much, Leonard. So it gives me pleasure to take Mr. Ibrahim Sule's profile. Very, very inspiring. He's currently the Director of Academics in the Nigerian Law School, Kano Campus, the Fellow of the International Bar Association. He holds a master's degree in law from University of Birmingham in UK and has 5 different other international diplomas from College of Law, England and Wales, now University of Law, London. Currently pursuing a PhD in electronic lawyering in the University of Utara in Malaysia. He's interested in the intersection between legal profession, ICT, internet, and AI. He has numerous publications to his credit in both local and foreign journals. And without much ado, Cecilia, the floor is yours. Thank you very much for being on this.
You're muted, sir. You need to unmute, sir.
I've seen it. Oh, thank you. Thank you. Yeah, my Lord, distinguished learned Silk, my senior colleagues and other participants, good afternoon. It's really a pleasure for me to be given this opportunity to make this presentation, and I will directly share my slides. Yes. The title of my presentation is ICT, Internet, and AI in Civil Litigation. I hope my paper is going to be as lively as the previous papers, because for some few days now we have been talking law, litigation, legal practice, and today we are getting into a dry area, that's ICT, Internet, and AI. I will divide my paper into 2 if time permits. I will talk about issues emerging as far as the intersect between ICT, Internet, and AI, and legal practice generally, and civil litigation are concerned. And then, if time permits, maybe use 5-10 minutes to demonstrate how we can make use of AI in some few things we do as lawyers, especially in drafting documents, in contract review, in analyzing some cases and what have you. So what am I going to talk about today? Yes, I'm going to discuss on a few things. First, I don't have to define what is ICT, what is Internet, or what is AI. I believe our participants, all of us, are very well familiar about ICT, Internet, and possibly AI, because for one to live, or I can humbly say exist in this age, one must either use ICT, Internet, or possibly AI one way or another. There is no way that one can do or carry out any task, either as a lawyer or as a medical practitioner or as ordinary person. There's no way one can live fully without using or interacting with either ICT or Internet or AI. So I will not be defining any one of these. I will just engage us on a small journey, so as we know the extent of the impact these 3 are going to or will continue to have on legal practice generally. I will talk on e-world, virtual world, and augmented world, as well as robotic world, and now the current trend, which is holographic world. I will also emphasize or draw our attention to the resourcefulness of the Internet, especially how Internet is divided into the surface web, the deep web, and the dark web. And then I will highlight on some legal practice opportunities tappable from the intersect between internet and legal practice. And then maybe list out some of the legal practice softwares, applications, and other tools that we can use to enhance our productivity as legal practitioners. And then I will narrow it down to AI and civil litigation, highlight on some of its prospects and the challenges. And then, as I've said in the beginning, if time permits, I may demonstrate how we can make use of AI, especially the common one, which all of us are familiar, or some of us are familiar with, that the ChatGPT or the Gemini or the Copilot, either one of them, I can demonstrate to us how we can draft maybe documents or review letters and some other things, depending on the time we have. And then I will conclude. And then we go to question and answer session. I don't have to remind us the developments that impacted the legal profession for very long years now. You'll all agree with me that legal profession, though it's a noble profession, but it's one of the very conservative professions in the world. For some few tens or hundreds of years that we have been practicing law, we have been doing it the way our predecessors did it and pass it down to us until recently when ICT, internet, and especially the AI come in and start to change everything as far as legal profession is concerned, and will continue to change a lot of things in legal practice, not only legal practice, but also in court management, in administration of criminal justice, in law teaching, and in a lot of ways, legal practice is going to will continue to be impacted and changed by the intersect between the ICT, internet, and AI. We can we vividly remember when we had text, we had fax, later we had radio and television technology, then came Bluetooth, infrared technology. Wireless technology was very shocking when it was invented. And then when the first computer was introduced, everybody was very well amazed. It was as big as a small room. Now, it's narrowed down to very portable devices, which we can all have in our pockets. And we also can remember when the 2G, 3G, 4G, and even 5G technology came, and how fast that changed everything in a number of professions, including legal profession. And now we are heading to have even 6G technology, the mobile technology, the smart technology. Now we have augmented reality technology. We have AI robotics, and the recent one, which is holographic. All these innovations have impacted on the way we do things as lawyers. This intersect inevitable marriage between ICT, internet, and AI has affected our life as lawyers. Not only as lawyers, in a number of ways we do things. In banking, we have a new aspect called e-banking. We have e-commerce. In agriculture, we got e-agriculture. We have e-medicine, e-learning, and the list will continue to come up. Our communications and interactions are becoming wireless. I don't have to say or mention some examples. Our locks are becoming keyless. Everything is less of a lot of things. Recently, there was an invention of waterless washing machine. Our tires becoming tubeless is becoming an old story. So also fireless cooking gas. Recently, Google and Apple and some other Chinese companies introduced driverless cars. cars that don't need anybody to be their drivers. You get in, you touch some screen, and there you are. The car will take you to anywhere you want to go. Self-flying planes have been transporting cargo, and soon they will be transporting public from one state to another, or from one country to another. This is inevitable. It's going to happen. We just have to prepare for the inevitable change. We recently have robot teachers, and they have been in use for some years, especially in China, Japan, Singapore, and they are teaching complex or more complex subjects than law, like chemistry, further math, and philosophy. Recently, we have cyber courts, and are being established in many countries, like in China. I have just read that in the last 2 years, their cyber courts successfully handled to conclusion over 12,000 cases. You just get into a platform, virtually, you state your claim, the other person, that the other defendant states his own side of story as response or defense, and the cyber judge will now rule who is right and who is wrong. We recently also have another wonderful and shocking invention in Estonia, where robot judges were developed and are being tested in other countries. Blockchain technology is also, and smart contracts are taking over. So also robot lawyers. We remember recently how a robot lawyer struggled to defend somebody in court, in a US court, and how I use he because they are being given citizenships in some countries, like in Saudi Arabia, robots are being given citizenship. So how the robot lawyer struggled to represent a defendant, and how he was faced with cases, civil suits against him by some lawyers in courts, and that prevented him from practically defending someone in court. And in 2020, I also read that a team of experts at Chinese Academy of Science developed what was to be the world's first robot prosecutor, and it has capacity for filing charges based on written case description, and its accuracy was estimated to be 97%. And this is very, very shocking. And these things will continue to come up, and they will continue to affect the way we manage our cases in courts. Let me now draw our attention to the resourcefulness of the internet. And as I've indicated in the beginning, the internet is divided into two. There is what is called the surface wave, and there's what is called the deep wave. The surface wave is estimated to be about 15% of the internet, that about 98% of you and me and other people can access. And search engines like Google, Yahoo, AltaVista, and other ordinary search engines can as well access. As I've said, it constitutes about 15%. 15% of the internet is on the surface web, and the remaining 85% is in what is called the deep web. And only 2% of people can access the deep web. And because the search engines, the Google, the Bing, the AltaVista, and some other search engines cannot be able to have access to the deep web. And it's about 500 times larger than the surface web. And that's where most of the information that require username and password are stored. And you cannot access the deep web without getting some special and specialized internet search tools. And without them, you cannot access them. Now, what's the size of the internet? No one knows the size of the internet because it's very large. But some estimates or some estimation was made, like in 2014. It was estimated to have about 1 million, or to contain or to store about 1 million exabyte of information. So what is an exabyte? Let me literally maybe dilute it for some of us who may not understand what is exabyte, what is terabyte, what is zettabyte, and what have you. 1 exabyte is about 1,000 petabytes. And 1,000 petabytes is about 1 million terabytes. And 1 million terabytes is about 1 billion gigabytes. So in 2014, that was about 10 years ago, the surface wave, which constituted about 15% of the internet, was estimated to have about 1 million exabytes of information. So let me dilute it further. It is estimated that for anyone to have 1 exabyte of video, one must have started recording the video about 237,832 years ago. That's for you to have only 1 exabyte of video. So if internet, that the surface wave, is estimated to have about 1 million exabytes, and for you to have 1 exabyte, you have to be recording a video clip continuously for the last 237,000 years. So you can understand how huge and vast and enormous the information in the internet is. And in 2020, the amount of data on the internet hit 64 zettabytes. I was talking about, I talk about 1 million exabytes in 2014. Now I'm talking about zettabytes. In 2020, the internet, that the surface wave was estimated to have about 64 zettabytes of information. And a zettabyte is about 1 trillion gigabytes. That's to have a zettabyte, you have to have about 1 trillion of gigabytes. And Cisco, which is one of the highly respected and famous computer manufacturing companies, released its report titled Global Web Traffic Report. And in that report, Cisco stated that the global web traffic exceeded 1 zettabyte for the first time in 2015. And it is expected to hit about 175 zettabytes by 2025, 175 zettabytes. So if you store if you stored about 175 zettabytes of information on DVDs, the stack of those DVDs will be long enough to circle the earth 222 times. 222 times. That's enormous. And if you attempt to download about 175 zettabytes of information at the average of the current internet speed, it will take you about 1.8 billion years to download. So, you know, I don't have to continue to maybe exaggerate how huge the information in the internet is. I will just leave you with this demonstration for you to understand how vast the internet can be. And I'm all talking about the surface wave, which contains about just 15% of the information contained in the internet. The remaining 85% is in the deep web that you and me cannot access without using some specialized tools. Now, I will move on to highlight on some of the activities or some of the benefits derivable by the use of internet as far as legal practice is concerned. I have highlighted a number of them, about 21 of them. And if time permits, I will maybe briefly highlight on a few of them to know how we can make best use of them. You can use internet as a legal practitioner to have what is called extranet. Extranet is like a sort of an online platform for collaboration and interaction between your law firm or you as a legal practitioner and all your clients. And there are a number of ways to do that. You can also use it to have an intranet. Intranet is the opposite of extranet. Intranet is a form of an online internal collaboration platform between a lawyer and other lawyers in a law firm, where you can review documents, where you can have a conference, a video conference, where you can manage drafting of some documents or some processes, and track the development of some cases you are handling in your law firm. You can successfully do that using internet as a legal practitioner. You can have a sort of collaboration unlimitedly. Now you can collaborate with anybody throughout the world, regardless of where you are or where the other person is. In fact, on any other aspect of legal practice, you can collaborate as far as legal practice is concerned. Cloud printing, you can use internet to print documents from anywhere you are. Now we have some wireless printers that you can connect to the internet, and because they are internet enabled, you can send to those printers documents to print from anywhere you are. All what you do is to create an account in a portal of the manufacturers of the printer, so that you would be like HP now. They have a platform for e-printing that you can draft documents in Canada and send it to a printer in Nigeria. And all what your maybe receptionist or your secretary or your colleague will do is to pick it and go and file it or serve it or store it. You can also have a cloud storage facility. You can store almost all your documents now online, and they are majorly secure. And there are some online insurance companies that you can subscribe to for them to ensure that they are securely stored, free from any online risk. You can also use internet to gamify trial. Before you venture into litigation, often gathering some facts, you can gamify the trial for you to see how practically it's going to happen when you start the trial really in court. Chat button, you can have a chat bot where you can create a platform for your client to ask questions and for the chatbot to answer based on the documents you feed to the chatbot. Document automation, e-trial, virtual legal practice, remote access, OCR, that is optical character recognition, digital archiving, client profiling, digital diaries, legal service outsourcing, case analysis, legal research assistance, virtual office. You can have your virtual office. You can have even some virtual phone numbers for those who may like to have some presence in other jurisdictions, like you would like to have an office in Canada, and there is no way you can move from Nigeria to Canada. You can have a virtual office and even Canadian virtual phone number, and anybody calling you will reach you. Legal analytics, and the list will continue to emerge. Let me pick some few of this and talk about. Okay, before I maybe take a few, as I've said, I've divided it into two. Now, as far as the interaction between AI and civil litigation is concerned, we may tap some opportunities like in terms of legal research, document review, predictive analytics, contract analysis, legal writing assistance, e-discovery, case management, natural language processing, expert witness selection, litigation analytics, virtual legal assistance, legal compliance and risk management, mediation and ADR, client counseling, and communication, trial preparation and presentation. All these are opportunities tappable from the use of AI, that's artificial intelligence in civil litigation. I will also pick a few and demonstrate how we can make best use of them. Now, legal practice management softwares, I've started a few. These are softwares that can help you organize your legal practice, connect you with your clients, also give you opportunity to collaborate with other lawyers inside and outside your law firm, also enable you to contact other justice-related agencies and corporate organizations. And these are usually cloud-based, and though there are some that are on free, that are free, majority of them are on subscription, and they are also mobile-based and are also computer-based. You can install them on your handset. You can as well have them on your computer. As I've said it, they organize your legal practice or help you organize legal practice, connect you with their clients, and a lot of other things that you can do. I've started a few of them: Cosmo, Lex, Matters.cloud, Moxtra, Practice Panther, CaseMap, Rocket Lawyer. All of these are very, very important as far as legal practice management is concerned. But of all these, I would recommend Microsoft 365. And for those of us who used it in their legal practice, they know and are familiar on how very effective, especially Team and SharePoint are. They can help you to collaborate and contact and connect and organize your legal practice and contact your clients from time to time, because they will give you a platform to have not only folders but pages for each one of your clients or for each one of the units in your legal in your law firm, and also for each of the legal practitioners you have. I would also recommend Google Suite, especially the enterprises or Google Suite for education, especially the aspect of it that have to do with Google Doc and Google Classroom, Google Calendar, and Google Meet. This Google Classroom, for those of us who use it, it's not majorly for teaching in the form of classroom. You can convert it to be a great and good tool or software for legal practice management. You can convert it, the classroom, you can convert it to be like your law firm, where you can create sessions, you can create class activities, you can create folders for each type of case you are handling, and you can allow your client to access, to upload documents, to answer some questions. It all depends on how innovative you are to use it in your legal practice, but it's very, very resourceful, and it will enhance one's productivity in legal practice. We can also make use of some dictation machines, especially text-to-speech applications and softwares. Sometimes we may be very, very busy that we may not have time to read and appreciate and make sense out of the large number of documents before us. We can make use of some softwares and even mobile phone applications to carry out this kind of tasks for us. They can read all Google recognized languages like Hausa, Igbo, Yoruba, Pidgin, and majorly Swahili, French, Spanish, Portuguese. All these major languages enabled in and can be recognized majorly on Google. And these applications can help you read any type of document in those written in those languages. And not only read for you, you listen, you can also convert the text which is read into any format. You can convert, maybe you can use, like you have a large or big brief of argument that you may not have time to go through. You can use this technology to especially the OCR, you can optically recognize the character, and that's very, very simple and easy. There are tens of applications and softwares that you can convert. You can first scan a document, convert it to PDF, and extract it into text. And now you can use this software to read this text for you and convert it into an audio format that you can read or you can share with your colleagues to listen to. And this can help you save some time and money. And their voice enabled. They can read any type of document, and they are available on our iPhones, on our Android phones, and they can read even web pages, they can read books, and they have a lot of extensions that you can make use of to maybe extend even their purpose. I have cited a few of them: iNova, Natural Reader, Zaboya, iSpeech, Audio Bookmaker. Most of these are even free. You can search Google Play or Play Store or App Store for iOS to have them installed on your gadgets. You can also make use of speech-to-text apps and voice-to-text softwares and applications. There are speech-to-text because what you do is to talk to them while they are typing it, like in your computer. A number like Google Doc, for instance, you can enable it to be recognizing you while talking, and it will be typing what you say. And you can make use of this technology even in court proceedings. You can enable it in court while proceedings are being conducted. While arguments are being canvassed, the software will be reducing what is being said into type. It will just type in any format that you would like it to type. And 80% of its recognition is very, very precise. I've cited a number of them, like Google Doc Voice, which is free and is very, very accurate. It has a very large list of voice commands, and the commands are even editable. You can edit the command to suit your own tune. And by the time you start using the voice recognition machine like Google Doc, the more you use it, the more it recognizes your voice, and it will reach a time when it will give you 90 to 95% of accuracy. Apple Dictation is also free. Windows speech recognition is free also. Dragon is free. We all can have these installed on our devices, and they can help us handle our litigations very, very, very well in an efficient manner. Translation applications, I have cited a number of them. They can help us translate from one language to another. Google Translate, Microsoft Translator, Yahoo, Belbafish, King Translate, Babylon, a number of them. In fact, tens and tens of them. And as we are going to see, with AI now, some of these are becoming even obsolete, because with AI, you can merge these three I'm talking about. You can talk to AI, it types, you can type, it converts to any voice you like. In fact, any person's voice you like. It can generate video, it can gamify or simulate a trial for you as a lawyer to see. It can translate actively from one language to another. I'm going to show us how. We can also have some digital and virtual assistants. They can help us to be more productive because they digitally remind us about the events, about the appointments, about the schedules of our cases, and the appointments with our clients. And most of these virtual assistants are all free. Some are even pre-installed with our mobile devices like Cortana, like Shirai, Google Now, Alexa. Speak to It assistant is very, very awesome. They all can help us. They can prompt us to see clients or to be reminded about a case we have in court or some other events that we want to attend. Digital diaries. They help us record client interviews or record court proceedings and rehearsals with witnesses. You can also use your own voice to remind you of the events and appointments. They are just like our own hard copy diaries, but in a digital form that we can install on our gadgets, mobile phones, and tablets or even laptops. I've started a number of them. Day one, you can create many diaries within one diary, and to secure it, it's even touch ID enabled, and you can export the interest in PDF or in any other form. And day one is free. You can search for it in Google Play. Grid diary is good because it always has cloud backup. Diaro is good because you can access it not necessarily by installing it on a mobile device. You can access it through any browser, and you can add photos, videos, and what have you. Google Keep for me is the best, and I've been using Google Keep for the last 10 years now. And it contains not only the events, the activities, the appointments I have, any other thing that I can quickly have access to. I keep it in Google Keep. When I get authorities that I'm not familiar with, I quickly copy it and store it in Google Keep, and it synchronizes across your devices. You don't have to install it on one device and activate it on another. Once you have it on one device, anything you store on your mobile phone, for instance, it synchronizes across all your devices. You don't have to copy and paste in the other devices. T-Metric, Google Calendar, Wunderlist, all these are good and can help us enhance our practice and become very, very effective and efficient as lawyers. The list continues. We have trial preparation applications like Trial Pads, Exhibit View. It can wirelessly assist you in presentation of exhibits. iTestimony. All these have to do with trial presentations. Trial presentations software. Digital surveillance and smart lock are very, very important because we manage and deal with confidential information with our clients. We have to lock them and keep them in a very safe place. So we have to use some digital surveillance in terms of smart cameras and smart locks. Law report also, by the use of internet and AI, is becoming visual now. In some countries, some companies have developed applications and softwares where instead of you to have a written law report, you would have visual law report because in their jurisdictions, the laws and the rules of court allow some individuals and companies to come to court and record visually court proceedings. And by that, you can have visual law reports. You don't have to read. You just watch the entire proceedings and see how arguments are canvassed, how judgment is presented, and how testimony and witnesses presented documents and what have you. Trial gamification softwares. These are softwares that can help you gamify a trial. Like somebody served you with the statement of claim and all other processes, for instance, and you also have preferred your statement of defense and other processes, and you are presenting your case before maybe Judge XYZ, whose also personality and history and even socialization development is stored in a form of software. That software can gamify how the trial is going to be for you to strategize and to know how best you can handle that kind of a case. Document drafting softwares are everywhere and are common now. So as far as AI and civil litigation is concerned, as I've said it, the previous list has to do with tools and benefits derivable from the intersect between internet and legal practice generally. These ones that I'm mentioning have to do with the intersect between AI and civil litigation. What benefit do we derive from the use of AI in civil litigation? I have listed a few, and I know the list will continue to emerge, and I may also skip some. I'm just highlighting. I know some of us are very well familiar with what I'm saying. I have been able to list only 14. One, legal research. We are familiar with that. We can use AI to conduct legal research. Of course, we have to be very, very careful when it comes to using AI to conduct legal research, especially in citing relevant cases and what have you. Sometimes AI can be very, I don't want to use the word stupid, but can be very, very stupid in even creating a case that doesn't exist and giving you its citation and telling you that it's relevant as far as so and so is concerned. So one has to be very, very careful. You have to follow it up with your own human and human feed to ensure that what the AI is giving to you is correct. Document review and discovery, predictive analytics, contracts, agreements, drafting and analysis, legal writing assistance, e-discovery, case management, natural language processing, expert witness selection, litigation analytics, virtual legal assistant, legal compliance and risk management, mediation. Okay, now let me take some of them. Like in terms of legal research, there are some AI platforms that can assist lawyers in conducting legal research by quickly retrieving retrieving relevant case law, statutes, and regulations. And these platforms can provide comprehensive analysis and summaries, and this can help you save your precious time and money. Law Pavilion have started incorporating AI in their platform. I've not used it to summarize any case or to analyze any law or statute, but I know they have recently incorporated that technology into their platform. I don't know of some other, but I know others will also come up, like Legalpedia, Compulo, Toma Legal Retrieve. I know all will have now to incorporate AI into their platform to assist lawyers in conducting meaningful legal research. Client communication and support. There are some AI chat bots and virtual assistants that can provide your clients with basic legal information and answer frequently asked questions and even schedule appointments with you. And this can help you improve client satisfaction and free off some of your precious time to achieve or to carry out some more complex tasks. For some law firms, I know they have started developing and incorporating chatbots to their websites and their extra net platforms, whereby you don't have to call your lawyer to ask some basic questions or to interact with him about your case. You just get into the website and start chatting with a chatbot about your case, and the chatbot, because it's fed with the client's information and documents, will answer some basic information about the progress of the client's case without necessarily contacting the lawyer. And that's very, very wonderful. The chatbot can even help clients schedule appointment with their clients, with their lawyers. And they can also remind both. They can remind the clients that on so date, so time, they are scheduled to meet their lawyer. They can as well remind the lawyers that on so date and so time, they are scheduled to meet with their clients. I don't know if this technology maybe soon can be able to arrange some virtual conference like this one so that we don't have to physically mobilize our technologies. When the time for the interaction comes, the chatbot will on its own schedule everything, and there we are online. We just start interacting among ourselves. I believe this technology is in the pipeline and is going to happen a few years coming. There is also opportunity for document review and discovery using AI software, where you can quickly sift through large volumes of documents to identify relevant information, especially for e-discovery, so that you can save your precious time and you can reduce cost. Sometimes, depending on the complex nature and the complexity of the cases we handle, we are bound to manage and handle large volume of documents that we cannot naturally, and it's very humanly impossible for us to within maybe few hours go through that large volume of document to come up with what we want to discover as far as a case we are handling is concerned. With AI, we can quickly do that. There are tens of or even hundreds of those platforms that are free now. All what you do is to either convert any large volume of document you have into a PDF or into a text, and you upload it into that platform, and you start asking questions as far as the document you uploaded is concerned. And no matter the large volume, or even if it's 10,000 pages, the software can quickly sift out any relevant information you need and prompt up with any question you may ask it. I believe some of us will think about confidentiality. Yes, that's one of the disadvantages of using internet, but there are many ways of killing rats. So there are many ways of handling confidentiality and privacy issue as far as AI and internet are concerned. And now we can even deploy these AI machines and models on our devices. Like I have deployed one on my laptop, which is about 6 gigabytes, and it has billions of information stored, and I can prompt it to give me thousands and thousands of answers as far as law is concerned. And I can also feed in the large language model platform with my local documents, and I can interact with it without being connected to the internet. So the technology is developing, and I believe a lot of things are happening, and we are going to have more few years coming. Contract analysis is another opportunity. By AI tools, we can review and analyze contracts to identify potential risk, inconsistencies, and opportunities for negotiation. And this can help us draft stronger contracts and negotiate more favorable terms for our clients. We can also use AI for legal writing assistants. There are some AI tools that can be used as legal writing assistants to help us draft pleadings, even brief of arguments, and other legal documents more efficiently. And these tools can suggest relevant legal citations and can improve readability and check for grammar and spelling. But sometimes we have to be very, very careful when it comes to using cases, because as I've said it, AI can sometimes be very, very stupid, and its algorithm can as well be manipulated to give wrong answers. And because of certain bugs also, it can as well give answers. We shouldn't maybe 100% rely on the answers, but we can maybe rely on the answers 80% while we check the remaining 20% and ensure that what answers it prompts us with is correct. We can also use AI in what we call predictive analytics, because AI algorithms can utilize or can analyze various factors related to a case, such as a judge's previous ruling, the general case law in a particular jurisdiction, jurisdictional trends, in order to predict the likely outcome of a litigation. And they can analyze also historical data, maybe of a particular judge or of a particular defense counsel, to predict the likelihood of certain case outcomes or settlement values, or even the likelihood of the judge's behavior as far as your case is concerned. This has not come to Africa at all, but it's been developed in some other countries like in US, Canada, Australia, Japan, and especially China, whereby AI algorithm, you can predict the likelihood of the you winning or losing a particular case, and 80% of the prediction is correct. Witness preparation. You can as well use AI to prepare, to analyze witness statement and identify areas where witness may be vulnerable on cross-examination. And this can help you prepare witnesses in a more effective manner for trial. You can use AI also for legal argument visualization. AI can take complex legal argument and present them in clearer and concise visual format for you to see how the case may eventually happen or take place. And this can be helpful for lawyers when communicating legal concepts to clients or judges who may not have legal, especially clients who may not have legal backgrounds. AI may have some limitations that we have to keep in mind. One is accuracy. AI is not perfect. It helps us do what otherwise we have to do in a fast manner. But we have to check it very well to ensure that it's perfect and is accurate. Its output should always be reviewed by a human lawyer. Bias. AI algorithms can perpetuate existing biases in legal system, and lawyers need to be aware of this potential bias and take steps to mitigate it. Data dependence. The effectiveness of AI tool depends on the quality and quantity of data they are trained. So this AI doesn't generate this data on its own. The data that you are going to use, you have to generate it yourself and feed into the AI model, and now you can start interacting and asking questions to the AI machine for you to have answers. I have cited a number of AI tools for lawyers. There is no time. I can see I have spent like more than 45, 50 minutes. I've cited a number of them, like Case Text, Co-Counsel, Lex Machina, Nexus Compose, Brave AI, Logix, and most importantly, these 7 are the most prominent and the most important. And I've been using the first 4 for the last 1 year now, because ChatGPT started in 2023. I've been using it to draft letters, to respond to emails, to draft, to initiate contractual.
Mr. Sule, sorry to interject. Please, I just, this is a very exciting paper. I got carried away myself.
Yes,
but if I'm carried away, but I'm just being reminded we need to round up within the next 5 minutes, so I can go into question and answer. But the slides will be available to our colleagues throughout the country. Thank you.
Okay, thank you, sir. Yes, I've been using ChatGPT, especially the ChatGPT 3.5, which is free. I think last week ChatGPT becomes generally free. Now you don't need to have any account with ChatGPT for you to make use of it. And soon it's also going to be connected to the internet so that you can have real results from other search engines incorporated or embedded into it. ChatGPT 4.0 is the most wonderful, and you can have unlimited answers to anything you prompt in to give you. But then it's on subscription. It's not free. And the subscription is about $20 to $30 a month. Gemini is free, largely, but there's Gemini Pro, which is also on subscription. Copilot for Microsoft. Gemini is for Google, which is based as far as personal interaction with it is concerned. It's more personalized than ChatGPT because it gives you personal, it enables you to have a sort of like personal interaction with it lively. Copilot is by Microsoft and is embedded in all the Microsoft platforms. It's embedded into Word, into any other platform for Microsoft is embedded with Copilot. Perplexity is good, is wonderful. Copy AI. Journey AI is wonderful. I've been using it to draft legal documents and to do a lot of things. Chat PDF, you can chat with any brief of argument that you convert to PDF. You can chat with it to extract the maybe argument, the pattern of argument of the other counsel, the judgment delivered by the court and the analysis of it, and a lot of things. Thank you so much for the time and for the opportunity. And that's the end of my presentation.
Thank you very, very, very much, Mr. Ibrahim Sule. This presentation blew my mind. I thought I knew a lot about the intercept. Maybe I'm old, so maybe our younger colleagues know much, much more than me. But I thought I knew quite a bit about the tools, how to use the AI, the internet, and not that I've been using them very much, and ICT, the intersection between this and our practice. But this presentation took it to an entirely new level. There are things I have not heard of at all. And the potentials are limitless. It's amazing, amazing. I mean, the gamification of trial is amazing. Now, I mean, how multidimensional it is, how you can use it to literally do a moot and mock trial to analyze the judge, case simulator, and all these things. And there are so many more. And a lot of us just think, okay, we have computer, we have internet in our offices. Yes, okay, some of us can draft documents with ChatGPT. But from what you've shown, and I'm sorry to go on for so long, you just showed that a lot of us have not even begun to scratch the surface at all, and the potentials are so much, so much. We just take it for granted. We read one or two articles, international newspapers about how ICT and AI is being used in legal practice, and I mean it's so scary from your presentation. If we are not careful, within the next 10, 15 years, those of us that don't really get into this fully, we will become dinosaurs. We will become extinct and we'll become extinct and we'll become irrelevant. Even in the practice, even in Nigeria. And it's not an international thing, it's a global phenomenon. It's here and there's no escaping it. In fact, I have to especially commend you because we were not, you were the one who proposed this topic. And it wasn't one of the topics we were initially thinking about for this particular training, but you proposed it, and I think it's a major revelation. I wish more of our colleagues tuned in and they paid attention. The slides are also fantastic. The graphics, the information. So I mean, there are a lot of, I mean, as you were speaking, we have over, I mean, we've run, even the chat box can't count the number of comments that have come in since you started presenting. And most of them are saying they want the slides. Everyone who formally registered for this training and register with your email address, you will receive this not only this slide, but all the slides for the conference. So if you have not properly registered, please register fully. We will forward all the slides to you. Thank you once again very much, Mr. Sule. I mean, this blew my mind. I mean, we all talk about IT and how it has changed life, but this made it so real. And it's showing that many of us will become extinct and will not become competitive if we ignore some of these things that are happening. Thank you very much. I will hand over to my colleague to anchor the question and answer session. Thank you very much again.
Thank you, sir.
Thank you, Leonard. So you said it all. Mr. Smith, thank you so much. This was indeed very fascinating. I doubt that we'll be able to take all the questions, but I must first note that David Akiemi in the comments said it is not boring. He started your presentation by saying it's a boring area. He says it's not boring at all. We're humbled by the knowledge that you have imparted today. Very quickly, from what's his name now? Akimbola Akinyilu. He says, can you kindly recommend some examples of trial gamification softwares? I think it's in your slides already.
Yeah, I mentioned some in my slide, but then let me update it with some that can be freely tried maybe by some of us to input fact of our cases and see how they can simulate or gamify the trial. Maybe I will update it inside the slide and send it.
Very well, very well. Thank you, sir. From Mohammed Lawal, he says, how can chats or discussions had via social media like WhatsApp be pleaded and proved during trial?
How can
conversations on WhatsApp, social media, how can you plead them and then prove them during trial?
Okay, I think that's very, very simple. It's just for one to comply with the provision of Section 84 of the Evidence Act, either to plead them in the statement of claim or in the statement of defense, and now seek to tender them by complying with the provisions of Section 84 of the Evidence Act.
Thank you. Lekon says your presentation is impressive. However, I am curious as to how the privacy of the client is guaranteed by the AI operators at the back end without breaching the confidentiality and integrity of the transaction. Please advise.
Yes, that's one thing that I think we have to struggle with for now. Like ChatGPT, like Copilot, like Gemini, Copy.ai, and in fact, even all other AI platforms for now are online based, meaning that for any document you want to have it reviewed, you have to upload it online to a platform. And that will definitely put the confidentiality information and some privacy of your client at risk. But then there is a way to prevent that. I have understood now, and I have started even to use the technology on my device where these AI models and machines can be deployed and installed on your computer, so that for any document that you would like the AI to review or to analyze, you don't have to upload it online. You can just upload it to that software which you install on your machine, and there you go. The software will start analyzing and reviewing the whole lot of information you feed it without necessarily being online. And that will definitely prevent you from breaching, or the likelihood for breaching the confidentiality duty of your client.
Thank you. One Matal kindly says, Thank you for this intriguing and insightful presentation. There's a lot of enthusiasm about AI and the opportunities it provides for simplifying our work. Are there any pitfalls you can identify as it relates to AI sidelining the human element in professional interactions and human relations in general? And do you have any thoughts on how to address such pitfalls?
Yes, maybe we should start thinking, we should have this at the back of our mind that AI has not come to, it has not come to make us useless, but rather useful. It has come to help us do what we should have to do in a fast way, so that we don't have to be doing every bit of our activities and any task we want to do using AI. We can use AI to enhance the way we would like to do something in a fast manner. We shouldn't rely on it on every bit of the information we would like to get, so that we may not make it may not make our brain useless. At least we have to have that at the back of our mind. And then secondly, we should also know that there are ways that you can manipulate AI to do what you would like it to do for you. AI is just like a motorcycle or a car that you get in to go to where you want to go in a fast and in a more convenient way. It will not go where you wouldn't like it to go. When you want to go to Lagos, you wouldn't just ask your car to go to Lagos. You have to get in, you have to fuel it, you have to get to the road, you have to drive it, and now you go to see or find yourself in Lagos. So also AI works that way. You put in the necessary information for it to give you and prompt you with logical and basic answers in a very fast manner. That's how we should be using AI, because now there are some concern among legal practitioners and professionals that AI has come to take over our jobs. No, it has not come to take over our jobs. It has come to complement what we do and make us more productive and more effective in what we do, if we know how to make best use of it. It's just like when computer came, or when the Industrial Revolution came some years back. People thought that they were to lose jobs, not knowing that hundreds of more jobs are going to be created. So also AI has come to complement what we do as professionals. It has never come to take away what we should be thinking with our own human brain. And in fact, we should ask ourselves, who innovated this AI? Is it not a man like you and me? It's a man like you and me, and the technology is developing. It's being developed day and day. It's being perfected to make our living and our profession more meaningful than the way it was before.
Thank you, sir.
Thank
Can you give an example of bias that AI can entrench on legal analysis and writing?
Can I give example of?
Bias.
Bias.
AI, yes, bias that it can entrench on legal analysis and writing.
Jenny, some call them Jenny, some call it Jenny, perplexity.ai, copy.ai, Coolbot doesn't analyze, but it summarizes documents. GPT 4.0 can review documents and analyze cases for you and give you the result promptly. So also Copilot. Copilot is enabled to analyze documents. Chat PDF is also enabled to analyze any document you input into it, and it will give you the necessary answers. You can chat with any document you upload to this platform. Gemini also can do that. Not only that, it can generate a lot of things. It all depends on the prompt. You know, the more good you are in commanding AI, that's in prompting AI to do anything you will ask it to do, the more it will give you. The less you prompt, the less it gives. The more you prompt, the more information you ask the more detail, like if you want, like you can prompt an AI to say, I'm a lawyer practicing in Lagos. I have a client called Mr. Sani Sule, who resides in Ikeja, and he is selling car vehicles. And he has a friend, Musa Sani, who wants to purchase a car, a Honda Accord 2018 at the sum of so. And he wants to be paying instrumentally. This can be a prompt to be put in ChatGPT, for instance. Now you can continue to say, draft a sale agreement between these two parties, make it so secure that they will not end up in dispute, and in case they have dispute, make it in a way that they can resolve it by mediation or arbitration before going to litigation. Give it more information. And you can even say that you need an agreement to be of like not less than 20 clauses or 30 clauses or 40 clauses or 50 clauses. The sky is your limit. And it can give you, in seconds, it can prompt you with a good and perfect sale agreement that you can only input a few things inside and you get your agreement ready. And all this can be free.
Thank you. And sir, do you think the AI analysis and writing will be without bias?
Yes and no. For in some cases, you know, for like analyzing some documents that you prompt in to an AI machine, it's very unlikely that the AI machine is going to give you a bias analysis of that document. However, for general questions and general issues, for instance, you may be faced with an AI bias because it all depends on how you prompt it and the type of the model that you use. You know, these AI models are different. Some are for professionals, some are for accountants, for instance, some are for general information, some are even AI machines are being customized now to give answers to certain topics and professionals. So depending on the prompt and depending on the type of AI you use, it's unlikely that you may be faced with AI bias for what you put in by yourself. But for general terms and general issue, you have to sift out what is bias and what is not bias.
Thank you so much, sir. We have a hard stop for 5:15 p.m. today as it's close of business for the week. And we thank you greatly for choosing. The questions just keeps coming in, and we're grateful that you've provided your slides and we will share with our participants. I can't say thank you enough. Over to you, team.
Okay, thank you very much once again. I thank you very profusely, Mr. Ibrahim Sule. I mean, this presentation, as I said, maybe because I'm old, I'm an old man, maybe younger, but this blew my mind because I thought, I thought I knew a bit about, okay, how these things, IT works. We're not even using one out of 10,000 of all the potential that could be used. And like every other industry, I think those who embrace ICT, AI, and all these tools most quickly and learn how to use it efficiently as lawyers, whether as litigators or even as solicitors, they are going to be the one to rule our profession, whether we like it or not. So it's done. I hope our colleagues this session very seriously. I mean, those who are the best on leveraging IT. It's becoming more and more and more obvious in every field of human endeavor. But this presentation made it so clear how important and impactful it can be for law in terms of making our work so efficient and doing more exhaustive research and testing and stress testing every position we've taken. I mean, it's for me, it's extremely revelatory. And I cannot thank you enough, sir, for this presentation. I hope our colleagues take advantage of it. I saw one question that is there any separate registration to get? No, there's no separate registration. It's just the same original registration you did. But I just imagine some people did not register and maybe their colleagues just shared the links with them. So if that was the case, it's unlikely that you will get, but it's not too late. You can still register. But we are going to share all the slides. So with all those who have registered, because we only have the emails of those who registered. So I thank you once again very much, sir. I thank all our colleagues who dialed in, all the delegates and all the facilitators. I thank everyone very much. I wish everyone a very pleasant weekend. We continue next week, Wednesday. Oh, no, next week is a free week because of the Salah holiday. So there will be no presentations next week. So we are going to commence, we're going to continue in 2 weeks' time. And we still have a lot of very outstanding facilitators to anchor the various topics we have. So I implore all our colleagues to continue to log in. But there won't be any trainings next week. We're going to commence in 2 Wednesdays from now. Thank you very, very much. Thank you once again, Mr. Sule.
Well, thank you so much.
I wish everyone a pleasant weekend and Barakat the Salah to our brothers and sisters that will be celebrating the Salah next week. Thank you very much.